judgment in the matter of NY Pakistan and the Secretary of State for Home Department?
For the reasons given in the judgments, supplementary judgments, which I now hand down, the court declines to treat these proceedings as proceedings for judicial review and to reconstitute itself as a divisional court for that purpose. Permission to appeal to the Supreme Court is also refused.
Appeal in the matter of NI Pakistan and the Secretary of State for Home Department.
Yes, good morning, my Lord and my ladies.
Good morning, Mr. Biggs. Well, you've just seen what I suspect is a vanishing breed, a hand down in court. But,
yes, well, let's hope it's not that rare a breed. But, so, my Lord and my ladies, I appear on behalf of the appellant, together with my learned friend, Mr. Zishan Raza. My learned friend, Ms. Emily Pottle, appears on behalf of the respondent, Secretary of State. My Lord and my ladies, just a couple of points of housekeeping before I summarise what, in my submission, are the issues that we need to look at today.
yes, which will not, I think, are not issues which merit a full-day estimate.
That I would agree. I would very much hope we'd be finished by lunchtime.
I would have thought so, but let's see how we go.
Yes, great.
Yes, sorry, you were going to say 2 points of housekeeping.
Well, some points of housekeeping.
Right.
I wouldn't say necessarily there are two. Just in terms of the bundles, we filed, I think, on Monday, a hearing bundle, electronically and physically. I'm not sure if it was physically filed Monday. I don't know whether my ladies and my lord have that.
Yes, I initially looked at it in the earlier bundle, but I had looked at the new one. I think my ladies only have it electronic.
No, I have it physically. I just don't have the other bundle.
Oh, I see. Right.
But I've marked up the other one.
Confusing. We all have both, and we will be flexible in referring to wherever we need to. But I think, in principle, let's refer to the hearing bundle. There's got more in it.
I'm grateful. That's what I'll be referring to in the course of my submissions, unless it would assist the court for me to give other references. There are only a few documents in there.
The lady will say if it creates a big for her.
Take my lord and my ladies too. Second point of housekeeping is the authorities bundle. I hope my ladies and my lord have that, both physically and electronically. The electronic version has bookmarks to assist the court. The physical version, I understand, does not have tabs, which is not ideal, but it does have page
Yes, well, in fact, I got my clerk to put in tabs, but it didn't quite work because they're printed double-sided. But don't worry, I think if we use page numbers, we'll find them. It's not a huge number of authorities. But if you have dispelled any minor irritation I might have had by apologising, but I think for the future, for those behind you, the tabs are always useful.
Yes, my lord, I think that is now understood, and I'm very grateful. For those using the electronic version, everything is fully electronicized, if that makes sense. There are bookmarks and hypertext links. Finally, there are three. I said penultimately. I'm sorry. We did yesterday file electronically a copy of the appellant's bundle in the First Tier Tribunal, just in case the court wanted to look at that. We've got hard copies here. I don't propose, my lord, my ladies, to take the court to anything in that bundle, but I appreciate, given the issues in this case, that the court may want to look at the evidence that was before the First Tier.
Well, we may or may not, but it's always useful to have it available. So you've done the right thing. But I think the sensible course is for us to see it only if it becomes clear we ought to see it.
If that does become clear, we have hard copies.
Thank you very much indeed.
And then finally, you'll see why I didn't agree to the 2 points. Finally, we have some additional authorities. I can hand them up now when it becomes relevant.
Well, to save it being done piecemeal, why don't you do it now? We have got one on the bench, which is Welcome, Trust and Hamad.
Grateful. That's from my learning friend's side, and it's on the same topic. It's all about the circumstances in which this court can depart from an earlier decision of this court. And we have 2 cases that we say determine the issue on one way of looking at the issue, if that makes any sense. So can I hand those up?
Yeah.
I don't know what my learning friend's position will ultimately be about young and bristle aeroplanes. Having spoken to her, I understand that she wanted to address the court on that topic first. And if my lord and my ladies are agreeable, I'll allow her to do so.
You mean first she wants to start the appeal?
No, I think what my learned friend suggested was that it might be sensible for the respondent to state its position on young and bristle aeroplanes and why it feels able to invite the court to depart from HA. In perhaps, I don't want to stand on my learned friend's toes, in perhaps the expectation that the court might give that short shrift or be able to deal with things quite quickly. But if that's not the court,
no, I must say it has some attraction, I think. Yes. Very sensible, Miss Pottle.
Yes.
Perhaps you can just tell us one thing. I thought I saw, but I didn't track it down again this morning, a statement that an application for permission to appeal to the Supreme Court had been made in HA and the decision's being awaited. Is that right?
Yes, that's right.
Have any inquiries been made as to...
Yes, I asked my instructing solicitor just yesterday if he could check with the Supreme Court registrar to see if a decision had been made. No decision has been taken on the application for permission to appeal, and so it is outstanding.
Very well, thank you.
I had hoped to interpose at this stage.
Excuse me, Miss Pottle.
Yes.
I'm sorry. Because of the children outside, if you could keep your voice up, it'd be helpful to me. Thank you.
Yes, of course. I'm afraid I'm struggling with a cold, so...
Oh, I'm sorry.
But I'll try my very best.
Well, here's one thought which might make it a bit easier. There's no reason why we shouldn't have a dispensation. You both move into the front row, anticipating only by very few years what I'm sure will happen. But because I think even without the children, who presumably won't be there forever, why don't you just both do that?
I'm grateful.
I also mean, I think both rows are captured by live stream, but you may be more of a standing row in the front row. Yes.
Yes. And so, no decision has been taken on the application for permission to appeal. The respondent applied to adjourn, to stay this appeal pending the resolution of that application, because the respondent's position is that HA-Iraq was wrongly decided, and the appropriate forum for the resolution of that issue would be in the Supreme Court if permission is granted. The application for the stay was refused by Lord Justice Lewis, partly on the ground that in his lordship's judgment, HA-Iraq wasn't central to this appeal. We obviously respectfully disagree with that, and of course, now having had sight of my learned friend's skeleton at a late stage, it is clear that HA-Iraq is central. But nevertheless, the respondent is realistic that this court is unlikely to revisit the decision in HA-Iraq, since it was given a short time ago and was obviously a decision handed down after full argument. And so if this court gives the indication that it doesn't want to consider that issue, or that I won't trouble my ladies and my lordship any further with those submissions. But I simply wanted to explain why they were. Yes,
I see. No, that's very helpful. Well, can I just make... If you're asking for an indication that it is our view, unless persuaded otherwise, that, well, not so much that HA-Iraq is correctly decided, though difficult for me at least to say that I don't think that's the case.
Yes.
But that whether it's correctly decided or not, we are bound by it. You are not going to try and persuade us otherwise. Is that right?
Yes.
And then, of course, there's a question lying behind it, but doesn't really need to be explored now, as to whether anyway it's inconsistent with PG Jamaica.
Yes.
Again, obviously in HA Iraq we said it wasn't.
Yes.
Well, I think unless my ladies want to clarify the position any further, we'll go out for a moment.
Well, could I just,
Yes.
on reflection, just refine my submission a little bit?
Yes.
Not accepting that you aren't bound by it, but that it would be your view that this is not the appropriate forum to revisit it, that it is something to be decided in the Supreme Court if permission is granted.
Yes, I see. Okay. Well, thank you very much. We will go out for a moment.
So we just keep streaming on.
Yes. Oh, I think it's 657. Let me just. Yes, 657.
Ah, I see. Thank you. You've highlighted it.
What rise? Supposed to just come.
Well, thank you, Ms. Pottle. It is indeed our view that we are bound by HA Iraq, and if you are, do not wish to try and persuade us that we're not, that's how we will proceed. Thank you.
So, my lord, my ladies, that short circuits things to an extent. In my submission, leaving aside the position that's just been established, there are four issues in the case that the court needs to look at. The first issue broadly is the right approach.
Just give me one moment while I just jot down.
Of course, I'm sorry.
Yep.
So, in principle, the first issue is whether is the correct approach of this court to HA, both in terms of whether it's binding on this court, and if it's not binding, whether the court is prepared to consider whether it's rightly decided, and then
that's the issue
what
that's
its conclusion is on that. In the light of my learned friend's position, that point seems to have dissolved from a practical perspective, but the court may still want to look at it in due course, and I'll therefore very briefly refer my lord, my ladies, to the authorities that we've handed up, and also the position in the skeleton argument. But it looks like that issue doesn't separate the parties from a practical.
I think my lady and I were about to say the same thing, but she got in first.
Yes.
Why? Why do we need to look at it?
Very well.
It's conceded that in this court we're bound and we should proceed on that basis.
I'm very happy to do so, my lady. You've got the authorities that have been handed up. They do shed light on one element or one situation in which it has been suggested that the court is free to depart from an earlier decision, namely where an earlier decision is inconsistent with a yet earlier decision of the House of Lords or Supreme Court, which seemed to be the way my learned friend was arguing the position. You can look at the cases I've handed up on that if you wish. The other elements are dealt with in the written argument, and I need to say no more. It's just to assist the court if you wanted to look at it. So that issue falls away. The remaining issues then are, firstly, did the upper tribunal err in principle? In particular, in respect of its reasoning with regard to the test in section 117C5 of the Nationality, Immigration and Asylum Act 2002. And the parties agree that this is the central issue before my ladies and my lord. The respondent accepts that at paragraph 48 of its skeleton argument. The second remaining issue, we say, are the implications for the upper tribunal's decisions if the upper tribunal did err in principle.
Well, hang on. Are we taking this the wrong way round? Surely the first question is, did the FTT commit any error of law? If it didn't, then the UT had no business interfering.
We accept, well, absolutely, and it's our firm submission that the First Tier Tribunal did not make.
Isn't that where the focus of this case should be?
Yes, that's not the order of the issues that I've identified.
Well, all right, I don't mind at all, sorry, but perhaps I haven't allowed you to develop your fourth or now third, and perhaps that's what it was going to be.
Well, that broad issue, what are the implications if the UT erred in principle, sweeps in my respectful submission, or is intended to sweep in, the observation that my lord puts to me. Namely, was it open to the First Tier Tribunal, in the light of the correct principles, to reach the conclusion it did?
Yes.
Because if the answer to that is yes, the upper tribunal's decision was wrong, because it wasn't open to the upper tribunal to set aside the FTT's decision.
Right.
I'm sorry, my lord?
I just said quite.
Yes, yes. But we do have the respondent's notice, which takes the position that the upper tribunal was right to hold that the First Tier Tribunal was wrong, but for different reasons. And in the light, we say, of the respondent's notice, if it's well-founded, which we say it's not, there should have been further fact-finding in the upper tribunal. And so that's why I've swept those 2 points. Was the upper tribunal wrong to say that the FTT's decision was perverse? And did the First Tier Tribunal nevertheless err in principle? I've swept those two issues up in that third category.
I see, okay.
Or now our second issue, in terms of what issues are live. I thought that was helpful, but if it's not, I apologise. And finally, just very briefly, what's the correct disposal if we're right in our position in respect to those first two issues?
Okay, that's fine.
So I'll be guided by the court, but my intention was to proceed to deal with whether the upper tribunal had erred in principle first, but I suspect that might not be helpful.
You see how I see it, and I think from our discussion how my ladies see that's the ultimate focus. But of course, the points about what the unduly harsh test involves are at the bottom of this, however you parcel it. So we don't really mind how you present it as long as we address them.
I'm grateful, my lord. Well, that's why I structured the issues in the way that I had, because it seems sensible to look at the questions of principle first, and then in the light of having done that, to see whether it was in fact open to the FTT to reach the conclusion that it reached, and therefore whether the upper tribunal was wrong. So can we briefly then turn to the relevant principles? We respectfully submit that the principles have been authoritatively determined in the decision of this court in HA, and those principles are summarised in the appellant's skeleton argument at paragraph 23 and 24. I don't propose to say much more about that in oral argument, because of course, my Lord Justice Underhill is well aware of the decision and reasoning in HA, but I suspect ladies too are very familiar with the case. But if we turn briefly to my skeleton argument, it's page 6 of the skeleton. we summarise at paragraph 23.
Oh, sorry. I don't mind at all, but oh, I see. I was looking at the wrong skeleton. And there. Sorry about that.
From a lot. So I'm just trying to short-circuit our analysis of HA by reference to the written argument, because I don't think it's controversial, and the court, I expect, is very familiar with the reasoning in HA. We submit at paragraph 23 of the skeleton that you get these three propositions out of the core reasoning of HA, and I've given you, if you like, chapter and verse in the judgments of HA at paragraph 23 of the skeleton. So firstly, we say HA decided that section 117C requires an evaluative assessment of whether the consequences of deportation are unduly harsh, bearing in mind an elevated threshold reflecting the public interest supporting the deportation of medium offenders, but that threshold is not and cannot be as stringent as that imposed by the very compelling circumstances test. Secondly, the focus of that evaluative assessment in a case involving a qualifying child, viz. A case like this one, is on the consequences of deportation for the particular child or children. And thirdly, it's not possible to identify a level of harm that would normally or ordinarily be endured by any child because of deportation. We say that is a reasonable summary of the key reasoning in HA and its ratio.
Yeah, perhaps I would rephrase 3. So it's not a useful exercise to, or it's a possibly dangerous exercise to. But
yes, it may be that I've gone too far, but I don't demur from that summary. And so at paragraph 24, to assist the court in respect of the appeal before it, we've identified 3 potential errors that the court recognised in HA that might arise if those 3 aspects of its view of the correct approach to 117C are not followed. I'll just let my ladies and my lord read paragraph 24. I don't propose to take the court in the raw, so to speak, to HA Iraq in those circumstances. We've set out our position, as I've explained, in respect of what HA Iraq decided in the written argument. And at paragraph 26 onwards of the skeleton, we explain how the reasoning in HA is simply inconsistent with the reasoning of the upper tribunal in this case. At paragraphs 26 to 31 on page 7 of the skeleton, we explain why the upper tribunal's reasoning at paragraph 27 of its decision, which I've quoted to assist at paragraph 26 of the skeleton, is, with respect to the upper tribunal, wholly unsustainable in the light of this court's decision and reasoning in HA. And just to crystallise why we say that is the case, I'm sorry, I'm not.
no, go on.
Just to crystallise why we say that's the case, we say at paragraphs 29 and 30 that the upper tribunal's statement of principle firstly is flawed because it rests on an assumption that emotional harm is intrinsically less significant than other forms of harm, most clearly inconsistently with Lord Justice Jackson's judgment in HA, see para 159 of HA. But secondly, and more fundamentally, this is para 30 of the skeleton, the upper tribunal's approach at para 27 of its reasons rests on the view that a normal level of harm can be identified or can helpfully be identified, and that this threshold must be exceeded before section 117C5 can be satisfied.
I mean, is another way of putting it along the same lines, but not quite the same as paragraph 30, is that what the upper tribunal did was took the particular factual situation in PG and the Court of Appeal's finding there that that particular factual situation did not justify the conclusion that the FTT reached, and elevate that into a legal proposition based on the apparent similarity, or what appeared to them to be the similarity of the facts in PG in headline terms to the facts in this case in headline terms. And a passage you don't refer to, I think, in HA Iraq, which I think was certainly something that the court attached some importance to, was, I can find it if necessary, but that it is dangerous in this area to develop a doctrine of factual precedence. And it wasn't just us that said it. The upper tribunal from which we were hearing the appeal went out of its way to make that point. So it's clearly, which was a presidential panel.
Yes.
That perhaps we will just look at it, because I think it's a point in your favour, but I think Ms. Pottle needs to know that I at least see some force in it. If we look at HA Iraq, which I now have to remind me which tab it's behind. Here I found it.
So it's tab 4 starts at page 28.
We at para 129, page 71 in the bundle. We say some rather dampening things about the use of the facts of one case showing what the answer should be in another case. And we quote what the President, Mr. Justice Lane, said, although the application of a legal test to a particular set of facts and sometimes shed light on the way in which the test is to be applied, it's the test that matters. If this were not so, everything from the law of negligence to human rights would become irretrievably mired in a search for factual precedents. Well, that's a colourful way of putting it, but that is, might it be said, that's really what the upper tribunal in this case has done. They've taken the facts of PG and said, well, they're quite like the facts of this case, and so the FTT must have erred in law.
I would agree with that. On a correct understanding of what PG and the other case, KF, actually did, because as you've seen from the written argument, we say, and we don't need to get there because of the binding effect of HA, which has been effectively conceded. We say PG and KF, the other case relied upon by the Secretary of State and referred to by the upper tribunal below, didn't decide any new question of principle or set out guidance. Those cases merely purported to apply KO to the specific facts and evidence in those cases. And that's why, in my respectful submission, although I don't need to say this, the court in HA was right at para 61 to say that there was nothing inconsistent with those authorities, with its analysis as to section 117C5 and the decision of the Supreme Court in KO. The difficulty, I suppose, with looking at the upper tribunal's reasoning through that prism is that at paragraph 27 in particular, the upper tribunal purported to set out a legal set of legal principles, which it perhaps derived from the factual matrices of PG and KF. But we say that wherever the upper tribunal got its principles that set out at para 27 of its reasoning, those principles were wrong. That's all we say. And we've explained in the written argument why we say those principles are wrong by reference to HA. But if on a proper analysis, what the upper tribunal did was to elevate, if you like, a factual precedent to some kind of legal precedent, then that itself was plainly an error of principle or law. I mean, interestingly, my learned friend does refer to paragraph 129 of my Lord's judgment in HA for support, in support of the suggestion that it's appropriate in some cases to look at the factual matrices in other cases as a cross-check So
yes,
you can't win,
we
really.
were, I hope,
But-
commonsensically, and as the upper tribunal said, of course, in the real world, it's quite right that practitioners get a feel for how these things are applied by looking at similar cases, but it's dangerous to do more than that.
I of course respectfully agree with that. And if the upper tribunal on the correct analysis did do more than that, and that explains its statement of principle at 27 and the way it applied that principle in the subsequent paragraphs, then that would establish an error of law. And we do acknowledge that. It's interesting, actually, since we're on this topic, to note what Mr. Ockleton said when refusing permission to appeal in this case. I think he made exactly the same point that my lord puts to me, that there are no precedents in fact. I'm not sure whether that supports my lord's observation, since Mr. Ockleton refused permission to appeal.
Well, I think he obviously thought, rightly or wrongly, that what you were doing was saying that the facts were more like those of HA.
Precisely.
I don't think that's a path down which we want to go. It can be used, and he says in HA, part of the problem in HA, is really reminiscing, or about interpreting KO, is that there was various factual scenarios in KO, and some of the cases they looked at, which were quite difficult to distinguish between, and yet some were said to go one way and some were said to go the other, and that's why it's a...
And there's the oddity of Upper Tribunal Judge Southern's reasoning.
There were all sorts of oddities.
Yes.
We didn't go too far into it, but it just illustrates you want a clear principle, and ask yourself in any appellate capacity, has the upper tribunal departed from that? Has the tribunal under appeal departed from that principle in their approach? And
in fairness to the upper tribunal, it did think that the First Tier Tribunal departed from a correct understanding of 117C5 insofar as the upper tribunal's decision was perverse. So that required...
The FTT's decision.
I'm so sorry, yes. The FTT's decision was perverse. So that required the upper tribunal to understand the limits of 117C5.
Yes.
And it did that by reference to its statement of principle at para 27.
Exactly,
but we say it was wrong at 27. And in the subsequent reasoning, I don't develop that point about subsequent reasoning orally, but you've got paras 32 to 41 of my skeleton, where I set out carefully, or we set out carefully, why the upper tribunal's reasoning at paras 28 to 30 of its decision is clearly inconsistent with this court's guidance in HA. And I don't think I can improve on that analysis orally, so I won't attempt to do so. So we say for all of those reasons that the upper tribunal got it wrong in principle with respect. And the implication of that, this is now the second live issue, the implication of that is that it was open to the First Tier Tribunal to conclude that the appellant's deportation would have unduly harsh consequences in respect of the children. And we explain briefly why at paras 42 to 44 and 59 to 62 of the skeleton argument. So the first point we make, this is para 42, is that, as was acknowledged in HA Iraq, the application of section 117C5 calls for an evaluation by a fact-finding tribunal. It's not, if you like, a hard-edged provision. And we cite paras 53 and 57 of my Lord's judgment in HA. I won't take my Lord and my ladies to HA, but paragraph 57 is perhaps most striking in this respect. The court acknowledged there that if the correct principles were applied by a first instance tribunal, then it's unlikely that it will have erred. The second point we make is that the First Tier Tribunal did identify the correct legal principles. At paragraph 29 of its reasoning, and I think we should briefly turn that passage up. So, in the hearing bundle, the First Tier Tribunal's reasoning starts at page 104. And para 29 is at the top of page 111. And in my submission, the summary of legal principle at paragraph 29 of the First Tier Tribunal's reasoning is perfectly sound. Indeed, in the upper tribunal, that much seems to have been acknowledged.
Yes, the upper tribunal is complimentary, I think rightly complimentary, about the carefulness and correct self-direction.
That's right.
Of the FTT. They just say, having directed itself correctly, it came to a perverse
conclusion. Although, as I've suggested, it may also have been saying that the First Tier Tribunal didn't quite appreciate the true limits of 117C5. But just to give you the reference.
Yes, but I mean, as far as language is concerned, in a way, the self-direction at 29 is, if anything, slightly more favourable to the Secretary of State because... sorry? Yes, exactly, because the new... what we did in HA was just rather nuance what was meant by necessarily to be implied and said some things about what Lord Cranworth must have meant by that. So the self-direction is it's not surprising that it couldn't be challenged. It's more favourable to the Secretary of State, perhaps, than
yes,
it need have been.
Yes, and if that's the court's view, obviously that doesn't assist the Secretary of State before my Lady and my Lords. Just to give the reference to the upper tribunal's point about the correct principles being identified by the FTT, and indeed, as my Lord puts to me, a compliment as to the careful reasoning of the First Tier Tribunal. It's paragraph 25 of the upper tribunal's reasons, pages 90 and 91 of the hearing. And the third point we make is that the First Tier Tribunal's conclusion on undue harshness is supported by sustainable and, in fact, unchallenged findings made by the First Tier Tribunal in the light of ample and sufficient evidence. That's borne out in my submission by reference to paragraphs 30 to 32 of the First Tier Tribunal's reasons when considered in context. And I've given the relevant passages to provide that context at paragraph 42 of the skeleton. I should just say at this stage that the judge's reasoning at paragraph 30, I think perhaps we should look at this.
Yeah.
So, Judge Talbot's decision, as I say, page 104 of the hearing bundle.
Mr. and Mrs. Imran gave evidence and were cross-examined.
Indeed, and that their oral evidence, which is faithfully set out in the First Tier Tribunal's reasoning, was accepted in full. And there's been no challenge to that finding, and indeed, before the First Tier Tribunal, no point about credibility was taken. See paragraph 27 of the FTT's reasoning, page 110 of the bundle.
But there's even if, of course, there was no challenge to their credibility. Sorry, the tribunal accepted their credibility and made findings in line with their evidence. But inevitably, when you reduce the impact of that evidence to writing in a short decision, all the nuances around that evidence can't properly be captured. And what the upper tribunal didn't have is that, as Lord Hoffman put it, penumbra of imprecision around the factual findings.
Yes, my lady, and that's the point I'm coming on to with respect. I of course agree with that. And this builds into a point I will come to shortly about the correct approach in this court, or indeed in the upper tribunal, when a challenge to the evaluative judgment undertaken by a first instance tribunal under 117C is mounted. But the point I was just about to make, my lady, is that paragraph 30 to 32 has to be considered in the wider context. And if we look at paragraph 30, which is really the centre of the First Tier Tribunal's reasoning, this is page 111 of the hearing bundle. It's set out in the written argument, so it will be familiar to my ladies and my lord. I think, being fair to the respondent, it is the case that the reasoning in paragraph 30 could have been expanded upon. But the submission is that, considered fairly and in context, and bearing in mind that the First Tier Tribunal was best placed to conduct the evaluation called for by 117C5 in the light of the evidence before it, this reasoning is more than sufficient to show a decision that was open to the FTT.
Have we got the grounds of challenge from the Secretary of State? I've seen these, haven't I?
We had it in the original bundle, definitely.
From the FTT to the UT. Should be here, shouldn't it? It's page 90. It's page 98.
Yes, I think it's 90.
Oh no, sorry, that's the permission.
Yes, exactly. 99. You've got the notice of appeal, and then at page 101, you have the grounds.
Yes, this is rather how the Secretary of State tends to very diffuse pleading.
Yes.
But it's a fault on both sides, I have to say, in this field.
Yes.
The assessment of risk of offending that has led to the grant of permission.
Yes.
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 And there's been no respondent's notice on that point, and the upper tribunal wasn't enamoured with it.
No, not at all.
No.
3 and 4.
Yes, I mean, but it's not at all clear. I don't actually know how it went to the upper tribunal. I probably should have picked this up, but an appeal on the basis that the evidence below didn't justify the findings would have required the upper tribunal to look at the evidence.
Yes.
And maybe they did.
Well, what the upper tribunal did, we can go to the upper tribunal's reasoning, is to set out the principles at 27, apply those principles in the following passages, and then to conclude at para 31 that in the light of its analysis of the decision in KO and the other authorities in 117C5, the reasoning the learned judge gave at para 30 not capable of justifying the conclusion that the undue harshness test was satisfied.
Yeah, so they didn't. What you would have to do, does sometimes happen, is, if it's a true perversity argument, is you have to see the factual material, and indeed you have to see, unless it's agreed or sufficiently summarised by the FTT, the notes of the oral evidence.
Yes.
And the so-called record of proceedings, which is in practice, I think, the FTT judge's notes, have to be produced and looked at.
Yeah, that would be the logic of a perversity challenge. Perversity might be another way of just saying Wensbury, but But if perversity means decision not open, which of course is broadly
Yeah.
just decision not open to the tribunal, but if that's in the light of the evidence, but if that is the position, then yes, you would need to conduct an evaluation.
It doesn't look as though the UT did that.
The UT didn't do that, as
I mean,
I've tried
my
to...
lady and I are very familiar with this. My lady on my right also, but certainly in the employment context,
Yeah.
the EAT generally doesn't like perversity appeals, but where there's genuine perversity appeal, you have to have all the material the FTT had. You get
Yes.
a call for the notes.
Yes, well, the classic perversity challenge is saying the evidence was insufficient.
Yes,
or
the evidence
absent.
didn't justify this
Absent
conclusion.
would be
Yeah.
the more straightforward way of making the point, yes.
But this was done not on that bit. This was done on the basis of the facts as disclosed by the
Judge's
by
reasoning.
the judge's reason.
In the light of the statement of principles
Yes.
that I
Okay,
addressed.
thank you. That's helpful.
Can I just because otherwise I'll forget with respect, when I was making the submission a moment ago, that paras 30 and 32 don't say everything that could be said, but are sustainable when considered in context and bearing in mind the evaluative exercise vested in the FTT. And one reason for that is set out in footnote 2 of my skeleton, where we point out that, properly understood, what the First Tier Tribunal was saying in respect of financial implication from the appellant being imprisoned was that there was an inference that if the appellant were deported, there would be a very substantial financial burden on the family. And that point also carries over to emotional harm in my submission. The judge's reasoning at para 30 was basically saying, in the light of the evidence as to what happened because of the appellant's imprisonment, we can infer that the situation would be a lot worse, unduly harsh, if the appellant were deported. And properly understood, that analysis was perfectly open to the judge applying the correct principles.
Well, and the fact of Mr. Imran's absence in prison enabled actual evidence to be identified as to the financial and emotional and other harm.
Exactly, my lady. That's why in footnote 2, what we say is that really what the judge is doing is he's using evidence of fact, primary fact, the historical events, to justify an inference, albeit perhaps to a degree that influence is not set out explicitly. But properly understood, that's what the First Tier Tribunal was doing in my submission. And in any case, its reasoning, however one understands it, was properly open to it in the light of the principles that we've looked at by reference to HA. And this brings me to the point about the correct approach of the upper tribunal and this court to a perversity type challenge in respect of a first instance decision applying 117C5. And in my submission, the court should be very slow indeed to entertain such a challenge, both because of the point that my lord makes in HA at para 57 about the evaluative nature of the FTT's task, but also because of the principles that Lord Justice Floyd referred to in the MS Malaysia case at paragraphs 33 to 34. So can we just briefly turn up MS Malaysia? It's tab 7 for those of you with tabs, beginning at page 109 of the authorities. Just to contextualise this wasn't a Part 5A
It's a derivative
case.
residence case.
That's right, my lady. And the Home Office had argued that it wasn't open to the first tier and upper tribunals to reach the conclusion that the compulsion test, which imposed a high threshold, had been satisfied on the correct understanding of that test. So to a degree, there is an analogy in my submission between the type of challenge in MS Malaysia and the type of challenge in this case. And at paragraph 33, on page 119, going over to para 34, Lord Justice Floyd, with whom the other members of the court agreed, identified what I think, accurately call in summary a principle of deference.
Yeah. Well, I mean, you're right, obviously shows this, but I mean, it's very well established. You've chosen this authority, but there are several others the same effect.
Well, I'm very familiar with this one because I appeared in it.
I see.
But it seemed to me...
There's another one, Lord Justice, it was a theme for Lord Justice Floyd, but I mean...
Yes, that's
similar. There's a case called UT, which says the same thing. That's
right. UT says broadly the same thing. I'm not sure it goes so far as to refer to the point at para 34 about
no.
The sort of forensic evaluation which is entitled to respect. So this seemed to be a slightly more comprehensive statement of the deferential approach. But in my submission, though the guidance given or the principles set out in those two passages, 33 to 34, is fully applicable in this case and strongly indicates that it wasn't open to the upper tribunal to conclude that the FTT's reasoning was perverse. So that's our primary case, I think, my lord and my ladies, on the implications if the upper tribunal erred in principle. In short, the upper tribunal was wrong to say that the FTT's conclusion was perverse in the light of the correct principles set out in HA. But if we're wrong about that, and the respondent's notice brings in this point, the implication must be, we submit, that the upper tribunal was wrong in respect of its remaking decision. So just to flesh that out, my learned friend...
Because of not re-looking at the facts.
Exactly. That's the point.
Is that? I mean, it's all a bit of a. If this was a true perversity case,
yes.
You don't. Well, the upper tribunal happens to have an explicit remaking jurisdiction.
Yes.
Which can show wherever there's an error of law. But in other circumstances where that isn't such an explicit jurisdiction, take the example of the AT, for example, the approach we take is, if it is pure perversity, you are effectively saying, on these facts, only one conclusion was possible. That's why it's an error of law. Once you've said that, then whether or not you call it remaking, you don't remit it back to the FTT. It's a waste of time. You've just said, to the ET, as it would be in that case, because you've just said there's only one possible conclusion. So, if this is a real perversity case, in a sense, there isn't a separate remaking exercise.
Well, there are two broad possibilities with a perversity challenge of the kind that we've identified, a paradigm perversity challenge, where the argument is the evidence was not capable of justifying a Wensbury reasonable conclusion.
Yeah.
One is where the evidence did not, on any correct understanding of the legal principles, justify a positive conclusion. In that situation, my law would be right. But it's conceivable that a conclusion was reached which was not open to the tribunal on the evidence, which might then necessitate some further decision making.
I see. Well,
It may be
you're right.
I'm putting angels on a pin there. Yes. I think my lord is probably right with respect. But we say that so if that's the right way of looking at this, then it would follow that the FTT's decision was open to it, and the correct relief, and I'll come to this when I get there, would be to set aside the upper tribunal's decision and restore the FTT's decision, and that's our primary case.
Yes.
The reason I have to deal with the alternative position is because of the respondent's notice. Now, let me just flesh that out, as I say. In the respondent's notice, the respondent takes the position, as I think a fallback argument, that in the light of the court's analysis in HA, particularly my Lord's judgment at para 56 of HA, the FTT erred by failing to take into account all material matters. Now, we say firmly that is not correct, because as I've sought to explain, the First Tier Tribunal's reasoning at 30 to 32, when considered in context and applying the correct approach to deference and bearing in mind the FTT was best placed to evaluate the evidence and apply the test, the FTT's reasoning was sustainable. But my learned friend's position in the respondent's notice is no, even if the upper tribunal was wrong to conclude that the FTT's decision was perverse, nevertheless, it was right to set aside the FTT's decision because the FTT failed to take into account all material factors, namely some of the factors identified by my lord in para 56 of HA. As I say, we don't agree with that for the reasons I've given, but if that is right, the implication must be that the upper tribunal's remaking decision set out at paragraph 32 of its reasons was wrong. Essentially for the reasons my lord gave, because at para 32, the upper tribunal said, look, there was only one conclusion available in this case, and that was that the undue harshness test was not met. But the logic of the respondent's notice is actually that it might be open to the FTT or to the UT to conclude that the undue harshness test was met in the light of the court's reasoning in HA. And if that's the position, the point we take is that the respondent's notice amounts to a cross appeal in respect of the UT's remaking decision, albeit not in respect of the error of law decision. And so the implication would be that the matter would have to be remitted, in my respectful submission, for a fact-finding hearing. I hope that's clear.
I think it's clear. If it isn't, it's probably not your fault. It's because of the number of hypotheses on which.
Yes. Well, I think our written arguments.
Well, you can deal with it further in reply.
I'm grateful. So that brings me to the final chapter of my submissions, which is very brief, disposal. And I think I've covered really what I needed to say. If we're right in our primary case, it was open to the FTT to reach the conclusion it did for the reasons it gave, when those are properly considered in the light of the correct principles. And it follows that the upper tribunal's decision on error of law was wrong and must be set aside, and the UT's decision allowing the appeal should be restored. If the respondent's notice is correct, as I've sought to explain latterly, the implication would be that the upper tribunal's remaking decision is wrong, because the reasoning at para 32 would be unsustainable in that event, and the matter would then need to be remitted for a hearing in my submission. My learned friend and I have discussed whether it would be appropriate in that event to have the matter sent back to the First Tier Tribunal. I've taken the position that because of the upper tribunal's jurisdiction under section 12 to consider whether to remake or remit, the legally appropriate course is to remit the matter to the upper tribunal. And I think my learned friend accepts that. But in principle, it seems sensible for the matter to go all the way back to the FTT for a fresh fact-finding. If you're with us on the...
well, hang on, if the principle...
Sorry, not in principle, in practice. In
Oh.
practice. Forgive me, I misspoke. And from discussions with my learned friend, the court has done something similar in other cases, but
Well,
I don't need to trouble the
say,
court.
this is a confession of insufficient analysis on my part. In cases like this, not that I've had many, but I must have had one or two, I tend to send it back to the FTT if what you might call primary fact-finding is required, but only to the UT if it can all be revisited on the facts already found.
Yes.
Now, you say that's not strictly logical because the UT can itself hear evidence in its remaking jurisdiction, but it doesn't feel right, which is perhaps another way of saying what you're saying.
I'm saying, yes, in practice, it seems sensible, if I can respectfully put it like that, to send it all back to the FTT in this hypothesis, which is obviously contrary to our primary case. And the reason
there's a good overriding objective reason for not clogging up, as it were, the UT with fact-finding, primary fact-finding cases.
It's just that because I'm conscious of the statutory power in the upper tribunal under section 12, which requires it to consider whether to remit or remake, and because I'm aware that actually the upper tribunal often does decide to retain cases and remake them, even where some fact-finding is necessary, I'm conscious that in principle it might be
well, in principle, it's certainly
inappropriate to
possible
send back
for it
to
to
the
be remitted only to the UT, but I don't think the existence of the power to remake means that we ought only to send it back to the UT because it has that power. We can decide to send it right back. And as you say, the UT itself sometimes keeps it, sometimes sends it back.
And there are practice statements on this, which I won't trouble the court with.
Well, I think let's not spend any more time on
I don't
this.
need to trouble the court any further. But I, of course, agree that my lord's right, that this court would have jurisdiction to send it back to the FTT. The question is, how should that exercise of jurisdiction work in circumstances where statute does seem to vest a discretion in the upper tribunal as to what's to happen next? But as I say, I don't want to take more time.
It's so that Miss Pottle knows where we stand. I think I speak for both my ladies. If we get into a scenario where there needs to be further fact-finding, we think, well, it sounds as though there's no dispute, we have the power to send it back to the FTT, and this looks like the sort of case where it would be appropriate to send it back to the FTT.
And that is my position as a matter of practicality. You've got my point on principle, whether it's right or not, I don't know now. But just to avoid any doubt, our primary case is the upper tribunal's error of law decision should be set aside and the FTT's decision restored for the reasons I've given. My lord, my ladies, those are my submissions at this stage.
Thank you very much, Mr. Binks. Yes, Miss Pottle.
Yes. My lord, my ladies, before I begin my submissions in response, I think it's prudent for me to clarify something that I said earlier in the hearing. It's sometimes difficult, I think, in a hearing, not in writing, making one's position clear. The Secretary of State doesn't concede that the Court of Appeal is bound by its previous decision in these circumstances. I don't have instructions to make that concession, and there are authorities which go both ways. But the respondent doesn't seek to persuade this court to depart from H.A. Rock because, in the Secretary of State's view, the appropriate forum for that argument is the Supreme Court.
Yes. Well, if I said anything that suggested that you've gone further than you meant to go, I certainly meant to understand your position as you've just clarified it. So the formal position is not that you've made any concession, but that we have expressed a provisional view which you have not sought to argue against.
Yes, I'm grateful. Yes.
And therefore, in that sense, we're bound to proceed on that basis.
I think I may have mischaracterised your submission rather than my lord, and I apologise.
I'm grateful. So that being the case, I think firstly, I should deal in my submissions with the perversity challenge, which I think I'm not giving anything away in accepting that I'm on shakier ground there than I am on the point raised in the respondent's notice. Before I go to the judgment of the First Tier Tribunal, I think I need to take my lord and my ladies to the decisions, very briefly, in KO Nigeria and PG Jamaica, because they're, of course, what was relied on by the upper tier.
Yes.
So KO Nigeria appears in the authorities bundle at page 135. Pardon me, the section that I'm relying on appears at page 135.
135?
That's MA Pakistan.
I'm not sure.
Oh yeah, that's it.
No, it is KO.
Yeah.
This is one of those cases where the arcane principles that the editors of the weekly law reports follow mean that they give a case a different name from what everybody else does. I've never understood that, but this is KO Nigeria.
Okay.
If you look at page 122, it even says KO Nigeria at the top, but the running title is MA Pakistan.
Yes. To keep us on our toes, I suppose.
In fact, it is arcane and frankly, I think, not very sensible, but it is, the theory is it was reported as MA Pakistan below, and they want practitioners to be able to find what happened to it on appeal.
I see. I didn't know that. Thank you. The section I wished to draw the court's attention to is, it's very well known, of course, paragraph 23. Here is Lord Justice Carnwath's...
Lord Carnwath.
Yes, pardon me, Lord Carnwath's exposition of the phrase unduly harsh. He says it's clearly intended to introduce a higher hurdle than that of reasonableness. Further, the word unduly implies an element of comparison. It assumes that there is a due level of harshness, that is, a level which may be acceptable or justifiable in the relevant context. Unduly implies something going beyond that level. And then one line down, one is looking for a degree of harshness going beyond what would necessarily be involved for any child faced with the deportation of a parent. And I emphasize the word any child because, of course, that is a phrase which has been deprecated in the case law which followed by the Court of Appeal. I have particularly in mind the judgment of Lord Justice Baker in H.A. Rock. He said, we shouldn't have an any child analysis. It should be an evaluative assessment of each child's circumstances.
And not Baker, you mean Lord Justice Peter Jackson, I think.
Yeah, pardon me, what did I say?
Baker, doesn't matter.
Yes, Peter Jackson, sorry, that's right. And so I think it's important looking at first principles, if I can call it that, because KO is, of course, the Supreme Court judgment in this area, that there is, in fact, a clear indication from Lord Carnwath that there is an element of comparison, and what the First Tier Tribunal should have done was to look for a degree of harshness going beyond that which would be necessarily involved for any child. The only other passage I wanted to draw my lord and my lady's attention to in this judgment is at page 140 of the authorities bundle. On that page, Lord Carnwath is looking at the decision in KO. And the very, so there's an excerpt here of paragraph 43 and 44 of that, of the decision below. And I'm looking here at the bottom third of paragraph 44, where it was said, nothing out of the ordinary has been identified to demonstrate that in the case of this particular family, when balanced against the powerful public interest, although the children will find separation from their father to be harsh, it will not be in all the circumstances unduly harsh. And later on in the judgment, of course, Lord Carnwath says that he finds it difficult to fault the decision in KO, and therefore he does dismiss the appeal. And of course, I have in mind what my lord said earlier this morning to my little friend about the dangerousness of factual precedent. And there is several authorities which highlight that difficulty. But a factual precedent, if I can put it this way, can't give us the answer to a case, but it is nevertheless, it can be helpful. And I think even in H.A. Rock, my lord said that it could be appropriate in certain circumstances to look at other cases to make a rough comparison. And the reference here, it's page 71 of the authorities bundle. I think we looked at this passage this morning.
Yes.
Mm-hmm.
Yeah, so at paragraph 129, my lord said, I am not so austere as to say that a tribunal may not sometimes find it useful to consider the outcomes in other apparently similar cases as a cross-check, but the exercise can only ever be valuable up to a point. So I have to accept it's limited.
It's a pretty concessive sort of point, but still, I do say what I say there.
Yes. Then, carrying on the thread of this, of the kind of analysis which is required, if I can take the court now to the decisions in PG Jamaica, I have in mind in particular page 106 of the authorities bundle, paragraph 38.
Sorry, which I didn't hear where you.
Yes, at PG Jamaica.
Yep.
It should be page 106 of the authorities bundle.
Yes, thank you. I have it. Thank you.
And this is, of course, Lord Justice Holroyd's judgment. And in my submission, at paragraph 38, Lord Justice Holroyd is faithfully applying the guidance set out in KO, Nigeria. And the last sentence in particular of that paragraph I rely on. He says, the issue is whether there was evidence on which it was properly open to Judge Griffith to find that deportation of PG would result for SAT and or the children a degree of harshness going beyond what would necessarily be involved for any partner or child of a foreign criminal facing deportation. There is also, on page 108...
Who is this any child? What is the standard child against which you're measuring this test?
Well, my lady, I can see that there are some conceptual difficulties with having an ordinary child, because nobody is ordinary in every sense. But I think what Lord Carnwath had in mind was a rough comparison across the class of children whose parents may be deported.
What is that class? Who's in it? Are they children who've been perhaps abused by the parent who's being deported and wouldn't be affected at all? In fact, it'd be good for them for that parent no longer to have contact. Are they children who, for whatever reason, don't have a relationship with that parent? Are they children who have an incredibly close relationship? What is the class?
Well, I think it would include all of those children.
Well, in which case, what are you comparing it? I don't understand who the any child is against whom this comparison is being made.
Yes. I suppose there would be a class of children, and it would include those who, sadly, did not have a good relationship with their parents, or perhaps had been abused by them. But one would assume the majority would have a close relationship with the parent.
Why?
Well, I think the common understanding of family relationships is that there are some where...
So there is a common
No,
understanding.
and remember, the one thing that is common to this class is that the father is a criminal. The parent is a criminal.
Yes.
Now, of course, crimes come in all shapes and sizes as well, but it just I don't think you should make any assumptions at all. There's a risk of an optical illusion in this area. Because the cases that tend to come before the courts are the ones where there's a loving family and they're all together, and the parent, usually the father, has committed an offence which isn't all that serious because it's one for which they got 1 to 4 years and so on.
Yes.
That's the norm, but as my lady points out, it's not necessarily the norm at all. You can still have a subsisting parental relationship, which is the test, even if the parents are separated, like not at all uncommon these days.
No.
The child might be 17 and on the verge of leaving home anyway. Might be a baby that's never met the father. The situations are incredibly wide. I'm sorry, I'm really only making life more difficult for you by
No, I do.
repeating what my lady has said, but it's a very different, and you are bound, I'm afraid, by us in HA, I'm bound to say, I think rightly, saying you've got to read what Lord Conworth said in that passage in context. He can't have meant it in the sense in which, with all respect to you, you are suggesting he did mean it.
Yes. Well, I have to say, that intervention doesn't take me by surprise. I expected that.
I'm sorry to indulge myself.
All I can say is that Lord Carnwath said any child, and though it might seem unpalatable, particularly to people who have practiced in the family courts, as Lord Justice Peter Jackson said. But in my submission,
that was Lord Justice Baker, I'm afraid. I'm sorry, Ms. Bottle. Keep going.
Pardon me.
Yes, no. Your point. I understand. Your point is that it may seem unpalatable, but that's what he said.
That's what he said. Exactly.
Yeah. Well, I see why you make that submission.
Yes. I was just then going to draw my lord and my lady's attention to Lord Justice Hickenbottom's short concurring judgment. He just adds a paragraph up to Lord Justice Holroyd's judgment, and this appears at page 108 of the authorities bundle. It's paragraph 46.
Yeah.
And he makes the point that the unduly harsh test, of course, is compliant with Article 8.
He assumes inevitable distress.
Precisely. In a similar vein, the decision of the Court of Appeal in KF Nigeria also, in my submission, faithfully interprets or applies the judgment in KO Nigeria, and that appears at page 93 of the authorities bundle. The relevant passage is at paragraph 30.
I'm so sorry, can you give me the page reference?
Yes, 93.
It's paragraph 30.
Yes. And this is the judgment of Lord Justice Baker. And I'm looking in particular at a passage which is 6 lines from the bottom. Lord Justice Baker says, "The judge observed that it was a fact that being deprived of a parent is something a child is likely to find traumatic, and that will potentially have long-lasting adverse consequences, and that he was entitled to take judicial notice of that fact. But the fact of which he was taking judicial notice is likely to arise in every case where a child is deprived of a parent. All children should, where possible, be brought up with a close relationship with both parents, and children who are not will be at risk of suffering harm. But given the changes to the law introduced by the amendments to the 2002 Act, as interpreted by the Supreme Court, it is necessary to look for consequences characterized by a degree of harshness over and beyond what every child would experience in such circumstances." And then Lord Justice Baker goes on to consider Lord Justice Hickenbottom's judgment in P. Jamaica, which I've just taken you to. And so that is the, in my respectful submission, the backdrop against which the First Tier Tribunal judge should have considered the appeal. My lady has already noted that, in fact, the First Tier Tribunal judge did quote the relevant parts of KO Nigeria when he directed himself. And I can't quibble about that self-direction that he made. But the submission is simply, as my lord has noted, a perversity challenge that on the facts of this case, which were not disputed, the threshold for unduly harsh could not have been satisfied.
So there's no challenge to the direction in law given by the FTT, self-direction in law.
No, my lady. I suppose he could have referred to PG Jamaica, but he referred to KO Nigeria.
Yeah.
At the time.
So I'm taking that as no challenge to the self-direction.
Yes.
Thank you. And then you say it is a perversity appeal in the sense that there was no evidence to support the conclusion, or
No, but that the evidence, because there was evidence of a strong emotional tie, and my learned friend is quite right. The evidence which was given before the first tribunal judge wasn't challenged.
you didn't cross-examine at all.
Well,
Sorry.
at
not
paragraph
you.
27, sorry, I wasn't there, of course,
Yes.
but at paragraph 27 it says, Mr. Eden did not challenge the credibility of the appellant's evidence or that of his family members. So I'm not sure
Sorry,
whether you
which
questioned
FTT.
yes, the
Sorry,
FTT.
Page
Yes.
110 of the hearing.
Yes, but anyway, keep going. Yeah.
And so, I'm not sure they were questioned, but there wasn't a challenge to their credibility.
Okay.
And so there was some evidence there, I have to accept, of the close relationship between the children and their father, and
Yes, this isn't really, I mean, I may have introduced a red herring here by talking about evidence. This isn't really perversity saying that the evidence didn't justify the findings of primary fact. It's more saying that the findings of primary fact, which the judge makes, if you can call them primary fact, about the quality of the relationship, were not such as could justify a conclusion of undue harshness.
yes, exactly. So there wasn't enough there to say that it would be unduly harsh for the children. That's it.
And not there in the findings, not there in the evidence. I mean, the findings are based on the evidence, that's fine, but that's not the exercise you're doing, going back to the evidence and saying he didn't say that. Yeah.
So that's a very fine line between that and saying that the UT should replace the FTT's evaluation. You're saying, however, the FTT exercised their evaluative powers, they couldn't have found on the facts that they found that the test was satisfied.
Yes, exactly. I suppose it's a bit like withdrawing a case from a jury, saying that taking the evidence at its highest, no jury properly directed could have convicted. Similarly, taking this evidence,
Evidence or findings?
findings, so, pardon me, my lady, taking these findings, no judge could have concluded that the test for unduly harsh had been satisfied.
The findings are particularly close relationship, clear evidence, strong and reciprocal emotional ties, more contact with the children than the mother because of the nature of his work as opposed to hers. And this technically perhaps is more evidence than findings, but evidence of the suffering they suffered when he was away in prison.
Yes. I know, my lord and my ladies, that seems like quite a bold submission to make. But if one considers the upper tribunal's judgment, they have in their minds very clearly the decision in KO and the more recent decisions of the Court of Appeal in PG Jamaica and KF Nigeria. And you know, as I took you through them, in my submission they are a faithful interpretation of the law, which does demand quite a high level, put it that way, to satisfy the test of unduly harsh. And
But it's a judgment, isn't it? It's an evaluation.
yes, that's right. Earlier in the hearing, I think it was my lord, or no, in fact, I think it was my lady who referenced to my learned friend that the UT, didn't hear the evidence in this case, and forget the expression my lady used.
Penumbra of imprecision,
Yes.
which is the delightful phrase used by Lord Hoffman.
Very delightful. Wouldn't be available to the upper tribunal, who would simply be considering the judgment. There are a few things I think I could say in response to that. Firstly, of course, the UT is itself a specialist tribunal. These are experienced judges who will always be making decisions in their cases. Not always, because they do conduct rehearings, but often be making decisions on their cases based on the contents of a judgment. And they are specialists. But also, it would never be possible to have a perversity challenge of this kind if we didn't entrust the upper tribunal on inappropriate cases to make their own evaluation without having heard the evidence. It can't be the case that it's only the First Tier Tribunal who can make the proper evaluation. And then finally, what I will say that in this particular case, because the credibility of the appellant and the witnesses wasn't challenged, and the evidence was thoroughly set out by Judge Talbot. This was a case which would have been amenable to the upper tribunal considering the facts. There are cases where there are disputes about credibility, about a lot of the evidence, hearings that go on for a very long time, that would be less amenable. But this one in particular, in my submission, would have been amenable to that kind of review. That is what I wish to say about the perversity challenge, unless I can assist any further on that. Moving on then to whether the upper tribunal's formulation of the ratio in PG Jamaica was erroneous. And this, of course, is the second ground upon which permission was granted. And if I can take the court to the upper tribunal's judgment, paragraph 27. Page 91. So here, the upper tribunal, consisting of Mr. Justice Chamberlain and the upper tribunal O'Callaghan, Judge O'Callaghan, they distill the ratio of PG, and they say that we consider that PG is authority for the proposition that the unduly harsh test will not be satisfied in a case where a child has two parents by either or both of the following without more. Firstly, evidence of the particular importance of one parent in the lives of the children. And secondly, evidence of the emotional dependence of the children on that parent, and therefore of the emotional harm that would be likely to flow from separation. We emphasize the words without more in the foregoing formulation. It would not be sensible to attempt to set out in advance the kind of factors whose presence would support a conclusion that the test was met.
With all respect to those judges, I mean, it depends what they mean by it, but it doesn't. Evidence of the particular importance of one. Well, the whole exercise is seeing, or an important part of the whole exercise is saying just what the importance of one parent is. So it's a judgment of degree, and just saying it's not enough to show they're particularly important is, being ruder than I mean, meaningless, isn't it?
Well, if one looks at the context of the judgment in KO Nigeria and PG Jamaica and KF Nigeria, I mean, particularly KF Nigeria, where there is a a discussion about the relationship between a 3-year-old and his father and the emotional harm that he'll suffer, and Lord Justice Baker saying that is not enough, I think,
Well, saying it wasn't enough in that case.
It's perhaps unwise for the judges in the upper tribunal to try to set out a further formulation of the test.
What they were really doing, I'm afraid I've already put this to Mr. Baines, but at least you can see it coming. They were elevating the particular characteristics of that particular case into a proposition of law, into a ratio in the sense of a proposition. They call it a proposition. That's not really a useful exercise, or indeed a legitimate exercise. The ratio is, it must be unduly harsh, as explained in KO, square brackets, KO itself explained in HA. That's the only ratio, and then they apply it to the facts.
Yes. I certainly, when I read that paragraph, had in mind my Lord's comment in HA Iraq, that further exposition of the phrase unduly harsh will never be more than a limited value. So that I can certainly see the sense in that. But the question, whether it's unwise, did it lead to a material error by the upper tribunal? I think the first thing I can say in defense of the upper tribunal's judgment is that they do say without more, and that's an important qualification. What they're saying is that those 2 factors, which they've enumerated, wouldn't be sufficient. And if one adopts a generous view, in HA Iraq, my Lord made clear that it's a range of factors that are needed, that must be considered. Not simply emotional harm or the closeness of a family, but the ages of the children, the possibility of support from other family members, the financial implications.
Well, to be fair, those I think are all things that go to the degree, ultimately what you're looking at in a splitting the family rather than all going back farther. You are looking at the damage that will be done by that happening and making an assessment of just how bad it is. Is it so bad that it should outweigh the strong public interest in the deportation of foreign criminals? And for the purpose of that assessment, then all the points you mentioned come in. How old is the child? How close is the relationship? What other parental or family support is available that may to some extent substitute for the loss of the father's support, and so on. But the ultimate question is one of the degree of harm, which makes it unduly harsh.
Yes, but I think the upper tribunal's judgment, when they say those 2 factors won't be enough on their own, doesn't preclude a consideration of the other factors in that balancing exercise. They're not limiting themselves only to the two factors, which are the importance of one parent and the emotional dependence.
But they are saying that those 2 factors on their own can never satisfy the test. And in a particular case, where the evidence establishes that the evidence of both the importance of the one parent and the emotional dependence of the children on that parent is so significant, why isn't that enough?
Well, I think the upper tribunal judges would say that looking at the guidance in KO Nigeria and PG Jamaica and KF Nigeria, that the test is so high that they couldn't be enough.
But I don't understand why. What do you say is the reason why it can't be enough?
Well, you for one thing, you have to consider other factors.
But if the age of the children and the absence of other family support and the fact that the mother is working and the father is the primary carer, and the particularly close relationship, all of those factors feed into there being a degree of emotional dependence on this particular parent with a close reciprocal relationship, such that the harm that would be caused to these particular children if this particular parent were deported and separated from them is so harsh. Why isn't that enough?
Well, my lady, I had in mind that emotional dependence is of course a factor, but that the relationships, for example, with other family members, they do feed into emotional dependence, but I would characterize them as separate, important in their own right. So the two factors that are mentioned in paragraph 27, the importance of one parent and the emotional dependence, could be considered separate to the financial impact, let's say, of deportation, the relationship that the child has with their wider extended family, whether they will be able to stay in their home and go to their schools. There are many more factors, which I understand do feed into that one, but I think they are distinct.
But there is no authority, is there, for elevating one set of reasons above another, one set of factors above another, and for demoting these factors that are in little 1 and little 2. Are there? Is there?
Well, I mean, they're distilling the judgment in PG Jamaica, but my lady is right that is the only time I'm aware of it being put in that way.
Right. Thank you.
I would also add that this paragraph, 27, should also be seen in the context of this case, where the upper tribunal was considering a decision of the First Tier Tribunal, where it was really only these factors which were considered. So the First Tier Tribunal, as I'll go on to in a moment, when I discuss the respondent's notice, the First Tier Tribunal, though directed itself correctly in law, their analysis focused on the emotional dependence of the children and the importance of their father, which are relevant factors, but did not go on to consider, for example, the fact that there was a large extended family nearby which could support the children. Indeed, when the appellant was in prison, the maternal aunt moved into the family home to help look after the children. Those were factors which weren't considered by the First Tier Tribunal. So if one puts these comments in context, they're really discussing a judgment where it was only those two factors were considered. And finally, I would say that even if the court considers that the distillation in paragraph 27 was erroneous, I would say that it doesn't follow necessarily that the judges of the upper tribunal erred in their final assessment. They considered carefully, nevertheless, the judgment of the First Tier Tribunal.
But they were only entitled to do that if there was an error of law. If there was no error by the First Tier Tribunal, they couldn't interfere.
The point I'm trying to make is that even if you find that paragraph 27 is erroneous, it doesn't necessarily follow that their conclusions overall were incorrect. Because if one looks at
In their
paragraph...
conclusion that the FTT was wrong,
Yes.
correct? Yes.
Yes.
I see.
Because if one looks at paragraphs 28 and 29 of the judgment, they carefully considered the First Tier Tribunal's judgment and explain why the facts could not be enough to establish the unduly harsh bar. So, in a way, it would be possible to take paragraph 27 out of the judgment, and the judgment would still make sense. I don't think their conclusions necessarily depend on that.
They do say at 28, against that background, we've carefully considered the factors set out in 30 to see if they meet that test. So they're judging it against the test they've distilled, aren't they, at 27?
But they don't simply say these two factors were the only relevant factors, and so the test isn't met. They consider the ties between the appellant and his family. They consider the emotional suffering, put it that way.
It looks as though what they're doing at 28 is looking at the evidence of particular importance, and at 29 the evidence of emotional dependence, and saying there was nothing more. That's how it read to me, but it may be that that's not fair.
They also look at paragraph 30, at the separation causing increased stress, financial and emotional, in the mother. And pardon me, my lady, I'm now taking this out of turn, but I had intended to draw paragraph 32 of the judgment to the court's attention. To emphasize that the upper tribunal made clear that they accepted the facts as found by the First Tier Tribunal, and that they considered whether it would be necessary for them to make further findings of fact. But they couldn't identify any findings that could have been made in the appellant's favor, any further findings.
So it would be fair to say that they set out their test at 27. They apply that test to the findings as they were found by the FTT in relation to those two elements. They compare those elements and the way that they were treated in PG as a check or perhaps direct comparison, and therefore accordingly decide that there was no rational basis for deciding it was unduly harsh. Isn't that what they're doing at 27 to 31?
Yeah, well, they are comparing the facts as found to the approach taken by the Court of Appeal in PG and KF. What I can say is, of course, as I took the court to those decisions earlier, they are quite stark decisions. And they do deal directly with the issues of emotional dependence and relationships between children and their fathers, and the harm that they will suffer, and say, in those cases, appreciate they're not precedents of fact, but they say very strongly that they're not sufficient. And I think in that context, the upper tribunal's judgment is properly understood in its context. It is defensive.
Are we now coming to the respondent's notice?
Yes.
Yep.
I just wonder, will anyone be offended if I blow my nose?
No. Sympathetic.
The point in the respondent's notice is pretty brief. If I can take my lord and my ladies to the authorities bundle, I'm looking now at the decision in HA Iraq. It's page 51. The bundle is the relevant passage. sorry, it's at the bottom of page 50 is actually the right passage.
Yes.
And here, my lord is elucidating the kind of factors which would be relevant to the evaluative assessment of whether it would be unduly harsh. And I'm looking here at the fourth line from the bottom. Simply by way of example, the degree of harshness of the impact may be affected by the child's age, whether the parent lives with them. A divorced or separated father may still have a genuine subsisting relationship with the child. By the degree of the child's emotional dependence on the parent, the financial consequences of deportation, the availability of emotional and financial support from the remaining parent and other family members, and by the practicality of maintaining a relationship with the deported parent, and all the individual characteristics of the child. In this case, as I mentioned a moment ago, the children have an extended maternal family which live nearby.
Can you just show me the findings?
Yes, it's in the judgment of the First Tier Tribunal. Paragraph 19, which is page 108 of the hearing. So paragraphs 18 and 19. Although Miss Ilyas was born in Pakistan, she's lived in the UK from the age of 2. She's British, as are her children. All of her immediate family are here, including her 8 siblings, which are parents. They live close by. And then at paragraph 19, the appellant's sister-in-law gave evidence at the hearing. She said the appellant had always been a great father and played an active role in the children's lives. And when he was imprisoned, the children's mother was very depressed and found it difficult to cope, and so she moved in with them. But that fact does not feature in the judge's analysis at paragraph 30. His analysis at paragraph 30 is really just on the close relationship between the appellant and his children, which is plainly relevant, of course, and the emotional harm which they would suffer from his absence. The judge doesn't consider, as he should have done, each of the children individually, their ages, the fact of this wider family support, and why that couldn't, if this was his conclusion, mitigate the impact of the appellant's absence.
Notwithstanding that the maternal aunt was living with the family, the children experienced and suffered the harm that's recorded in the Hampshire Children's Services Assessment.
Yes.
So, to that extent, there doesn't appear to have been any mitigation of the harm.
Well, I suppose it depends what the baseline is, but yes, of course, they did suffer. Can't resolve that. But looking to the future,
But it isn't that why the judge had actual evidence of how, notwithstanding the close family, extended family, notwithstanding the fact that the maternal aunt was able to move in for that period of time, the children actually suffered educationally, emotionally. There was evidence of all of that. And
Yes.
then when Mr. Imran returned, things changed again.
yes, but I think he still had to, in line with HA Iraq, he still had to set out all those factors and explain why in his view, nevertheless, it would be unduly harsh. Because from the judgment, it appears as though he simply overlooked them. And maybe he didn't, but we, of course, only have his judgment to look at. And those factors which are necessary did not form a part of his analysis. And so then the question of disposal arises.
So those are the only points that you say were relevant considerations that were overlooked.
Yes. In my skeleton argument, the point is dealt with. At page 33 of the hearing bundle. The submission is a short one at paragraph 64.
Yeah.
The First Tier Tribunal failed to make an adequate assessment of the appellant's 3 children individually, as well as collectively, and by addressing the relevant factors. It considered the extent of the emotional ties and the emotional impact of the appellant's absence, but did not address the financial consequences of the appellant's deportation, the availability of emotional financial support from their mother and the other family members, the practicality of maintaining a relationship, or the individual characteristics of the 3 children.
Yeah.
And of course, it's not a factual precedent, but just comparing that with the treatment for the consideration by the FTT in Nigeria, it was lacking. And so then the question arises of disposal. In this case, of course, we received the appellant's skeleton at quite a late stage, where the appellant says that this point, in effect, amounts to a cross appeal of the remaking decision. And we've reflected on that, and my instructions are that we would agree that if an error is found on this basis, that the matter should be remitted for a fresh consideration of the issues. Bearing in mind also there's been quite a lot of time since the first hearing. There is another child in the family, so that does seem sensible. But in our submission, the matter should be remitted to the upper tier, for the upper tier to consider itself whether to conduct the rehearing there or to send it to the First Tier Tribunal. Now, I understand my Lord's comments earlier this morning that we could be a bit more pragmatic here and simply remit to the First Tier Tribunal. The court has that power, but the respondent's preference is certainly for the matter to be remitted to the upper tier.
Thank you very much.
Can I be of any further assistance?
Mr. Biggs, is there anything you want to add by way of reply?
I'm tempted, my lord, but I'm not sure if is there anything I can say that will assist my ladies and my lord?
Advocates who say they don't need to reply always get always well looked at for that kind of call. So no, not as far as I. There's just one point I've noticed which I should have picked up before. I haven't actually raised it with my ladies, but I don't think it's controversial. This case was not anonymised in either tribunal below. As you know, the precautionary practice here is that all immigration-related cases are anonymised. A decision should be taken at the PTA stage whether they should be de-anonymised. That doesn't seem to have happened here, and it has been formally listed in anonymised form, but the parties all done their skeletons with the full names, and I can't believe there's any proper case for anonymity here.
I think in principle there might have been, but we're at the stage where there hasn't been anonymity below, and so I don't think there's any purpose.
I think we will. It well,
That's what I thought.
yes. I'm sorry, I didn't pick that up before. Very well. We will be reserving our decision in this case. We appreciate the importance to the parties, and we don't anticipate being very long. Council will know, but I repeat it for the benefit of anyone else not in court, that the procedure will be that judgments will be circulated in draft, so that the parties can agree the terms of any consequential order, or if they can't agree, can submit short written submissions, so that we can resolve them at the time that the judgment is formally handed down. We'd be grateful also to have any typographical or minor factual errors drawn to our attention. But we're grateful to both council for their clear and succinct submissions.
Yeah, we're finished. That's it. Short and sweet.
Do you have a slip for us to take away for the consequential matters? I've got. There's sometimes a slip telling us where to email.
Yeah, that's you can have it. That's usually with
They will, and I've got at least Lord Justice Underhill's details.